of a claim. Generally speaking, if they have solicitors, the claimants and any beneficiaries contesting the claim will have to fund their involvement in the claim themselves, and the specific funding arrangement will depend on their circumstances and essentially whatever's agreed with the solicitors. So at Anthony Gold, we would generally be happy to act for potential claimants under a no-win, no-fee agreement, providing their case has merit. In the case of beneficiaries who are contesting the claim, we may very well be willing to act on a deferred fee basis if they stand to receive some money at the end that's currently locked up because of the claim. But again, the specific funding arrangement will entirely depend on whatever's appropriate, and ultimately it will be a case of the solicitor's time being charged at an hourly rate times the amount they've spent working on it, and subject to anything that's ordered by the court or agreed, the starting position would usually be that they have to pay their own costs, because that's the retainer they have with their lawyer. Obviously, a no-win, no-fee agreement is slightly different, but I won't go into detail on that. And just in terms of administrators and executors, then they're slightly different in that they can recover their costs from the estate and also be protected from adverse costs, so being ordered to pay other parties' costs, providing they remain neutral in the dispute and essentially just provide the information relating to the estate, which is what their role really is. Where it gets confusing, and this is more common than you may think, is where you've got an executor who is also a beneficiary with a financial stake who's trying to actively contest the claim. And in those circumstances, if there's one firm acting for them, you would hope that there would be two separate files set up, one dealing with the administration and one dealing with the defence of the claim, and so that those costs and the division of those costs are easily kind of recognised, that what can be recovered from the estate and what is essentially the personal costs of the beneficiary in that capacity. More often, you'd probably hope that there'd be two separate firms of solicitors, one acting for them in their capacity as administrator and one acting for them in their defence of the claim as a beneficiary.